Good morning.
Morning.
See, Donna was still getting dressed just like me, you know.
I was putting in my earring.
Well, I was putting on my tie.
Put that on in a minute.
Okay, you're all set to start, Senator Gray.
All right, thank you. Good morning. Welcome. I am Senator James Gray. Today we will be having public hearings on House Bills 223, 285, 484, 183, and 243. Before we get started, I will read through the checklist to ensure that the meeting that we are holding is in compliance with the Right to Know law. As chair of the Senate Election Law and Municipal Affairs Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with Governor's Executive Order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to the meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I'm confirming that we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom webinar for this electronic meeting. All members of the committee and select legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch or listen to the meeting on Zoom and YouTube and via phone by following the directions and links provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call 603-271-6931. In the event the public is unable to access the meeting due to problems on our end, we will adjourn and reschedule. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, let us start the meeting by taking a roll call attendance. When each member states their presence, please also state where you are and if anyone else is in the room with you during the meeting, which is required under the Right to Know law. I will call the roll. Senator Birdsell.
Thank you. Senator Birdsell, I'm in my home in Hampstead. I'm in the kitchen. I am alone in the kitchen right now. I will be visited, I'm sure, by my husband at some point during the session. And I do apologize. I'm going to keep myself on mute because the landscapers decided to do the leaves today.
Okay. Senator Ward.
Good morning. I'm Senator Ward from District 8. I'm in my home in Stoddard, and I am alone in the room.
Thank you. Senator Susie.
Good morning. This is Donna Susie. I'm at my home in Manchester and I'm alone.
Senator Perkins Coca.
Good morning, Senator Perkins Quokka. I'm in my home in Portsmouth and my wife will be in and out of the room, but I'm alone currently.
Okay, and I am Senator James Gray. I'm in my District 6 home here in Rochester, and I am alone in this room. My wife won't come in here, it's too messy. We will ready for the first public hearing on House Bill 223. And if you would call on the prime sponsor, I'd appreciate that.
I'll bring in Representative Joe Sweeney.
Representative Sweeney.
Thank you, Chairman Gray and members of the Senate Election Law and Municipal Affairs Committee. I'm proud to introduce House Bill 223 today. It's relative to political party access to a list of absentee ballot requests. I had sent over my written testimony yesterday over to the committee through email. So I'll try to keep this short, but this is really, in my opinion, a housekeeping measure that currently takes the current practice where political parties are denoted as agents of statewide campaigns in order to create subscriptions to the absentee ballot request list before the election, and just allows the recognized political parties in the state of New Hampshire to directly subscribe to that list. And it is a fee system, and the fee would be the same that the statewide candidates would have to pay for that. I believe last year it was $2,000. So it's determined by the Secretary of State as to what the fee is for the statewide subscription to the absentee ballot request list. I'm happy to take any questions from members of the committee. But as I said, I believe it's just a housekeeping measure that just kind of codifies current practice into state law.
All right.
Thank you.
Senator Ward has a question.
Thank you, Mr. Chair. I'm just curious, in the second paragraph there, you're talking about excluding voters who have presented to the supervisors of the checklist with valid protective orders. What are those valid protective orders?
Yep. So if a voter does have a privacy issue, it could either be a domestic issue or any sort of legal proceeding that gives them the right to privacy. They are scrubbed from the list, so we don't publicize their names and addresses. So that's under current private law that currently exists in the law regarding the voter data and the absentee requests.
Okay, thank you.
Senator Susie has a question.
Thank you. Thank you, Representative Sweeney. A couple, if the chair will indulge me.
Absolutely.
It wasn't clear to me from the language. Are we talking about both absentee requests and absentees that have been returned?
Just the absentee requests.
So the initial request, but not whether or not the ballot is actually returned.
Correct. The Secretary of State's office maintains the list of the requests that come in to apply for the absentee ballot, and that's what the political parties would be gaining access to.
Okay. And one other, if I may, just with regard to timing, the language doesn't, and the current language that you're trying to clean up as well, doesn't address the issue of timing. I recognize this last election was probably the greatest test we've ever had for our local officials, and they certainly shined through. But I wondered if there was any discussion when you presented to the House about, right now, I think it's like once a week access, twice a week as we get closer. Was there any discussion relative to timing?
We did not discuss that in the House election law. Right, as you're correct, Senator, it was once a week, and then as we got closer to the election, it became that twice a week distribution. And I obviously, if the timing intervals is something that you guys, if the Senate would like to take up, I'm in favor of that.
Thank you very much, Representative, and I'll probably email you offline. I do think that might be a good addition if you would accept it as a friendly amendment.
Thank you, Senator.
Additional questions? My list of people who've signed up to speak is exhausted now. Do we have anybody else that signed up since my list was printed?
I don't have any more signups, so if anybody else would like to speak at this time, please raise your hand now. And I'm not seeing any hands, Senator. Oh, I am seeing a hand now.
Do we have anybody in the attendees from the Secretary of State's office?
We do, yes.
And Mr. Scanlon, Deputy Secretary, I'm sure that there's people out there would love to hear your words on this, and I think Senator Susie would appreciate a question or two.
Thank you, Mr. Chairman, members of the committee. I'm David Scanlon, Deputy Secretary of State, and I would be happy to answer Senator Susie's questions.
I don't know if you were on earlier, Deputy Scanlon, but I basically had two. One was with regard to clarity of the language and whether this is access to both those who have requested ballots and those who have already returned them. That was the first one.
My understanding is that this would be just for those who have requested absentee ballots.
Okay. And then the second one was with regard to timing, and you might have caught part of that, but there's nothing specific in the statute relative to timing. It's my understanding that typically your office, the Secretary's office, provides the list on a weekly basis. And as we get closer to Election Day, every other week. If you would just address that, but then in addition to that, there seems to be a great deal of disparity, and I recognize this last election is not the best example because so many clerk's offices were overwhelmed. There's nothing with regard to timing, and there's a great deal of inconsistency in availability from the various towns, and I wondered if you could address that as well.
Certainly, and we're actually talking about two separate issues, and I'll address the bill first. And what this provision in the bill addresses is the subscription right now statewide candidates can receive in terms of the absentee voters. There is no frequency provision in the statute and how frequently we provide that list. But we start off earlier in the summer doing it every other week. And then as we get closer, say 4 weeks out from the election, we go to weekly. We could certainly do it more frequently than that if that's the wishes of the legislature. But the cost for that subscription is $2,000. It kind of dovetails on the purchase of the statewide list that we generate, because the information that's provided in the bill is simply the voter name and the voter identification number. With the identification number, you can access all of the other public information that is on the statewide checklist from the database that we sell. The other part of your question addresses the frequency of the obtaining the voter checklists from individual city and town clerks, where any candidate who is not a statewide candidate can go and obtain the list of absentee voters. Our guidance to those election officials, the city and town clerks, is to provide the list on a regular basis and let the candidates know when that list will be available, so that there could be some planning involved. City and town clerks, I mean, the larger cities and towns have regular office hours. They're open 5 days a week for a set period of time. But as you get into the more rural parts of the state, that's not the case. The clerks may not be open daily, and the hours that they're open varies. So, it might be easy to inform cities and towns that have regular office hours, have it available, 2 days a week, Mondays or Tuesdays and Fridays, let's say at o'clock, so that candidates can know when they can obtain the list. That may be a little bit more difficult in, a town like, I don't know, small towns like Orange or others where they don't have regular office hours, and it might only be open a couple of evenings a week. We're open to how you would like to address that. We certainly believe that uniformity in these processes are a good thing.
Great, I appreciate that. Thank you so much.
Okay, are there additional questions on this bill? Seeing none, if there's additional people, they need to raise their hand. I'll let Kristen explain all that.
So if anyone else would like to speak at this time, please raise your hand now. Not, okay, we do have a hand.
All right.
We have hands going up and down. Okay, the initials are MT. So could you please state your name for the record? You can unmute yourself.
Hi, my name is Marilyn Todd. The team had a little bit of a hard time finding the Zoom meeting. So are we on HB 285?
Nope, we're on 223.
Okay, so we already passed HB 285.
285 isn't.
That's
I
the next
apologize. Okay, so I just have to let everybody know. I'm sorry. I'm so sorry. Thank you so much.
285 is not being heard today in election law.
Oh,
So you may want to go back to the
the Zoom meetings.
Be able to look up the bill.
All right, thank you so much.
Oh, hired somebody else. Does he want to testify, he or she?
No,
All right.
thank you.
Senator
Thank you
Gray.
so much. Sorry, everybody.
Yes, ma'am.
285 is actually next, isn't it?
Yes.
Yes.
Oh,
Oh, so we're here. Okay, perfect.
all right. So just we'll put you on hold for a little bit and we'll get back to you. All right. Any other hands for this bill?
No.
We'll close the public public hearing.
Somebody hungry?
I needed more coffee or juice or something, and I don't drink coffee, so. And then we'll open the hearing on, I guess, 285. If you'd call the prime sponsor.
Thank you, Mr. Chair and honorable members of the committee. For the record, I am Erica Leon, representing Dairy, and I am the prime sponsor of this bill. On the checklist, that means you're considered eligible to vote. This past year, anyone on the checklist was able to receive an absentee ballot, even if they had no intention of returning to New Hampshire. For students from a big state so big that their vote doesn't seem to make a difference, it's very appealing to cast a vote that can tip the scales, and that's a big pull. And our law should not make it so easy for former New Hampshire residents to cast a vote here. Disenfranchisement isn't just being denied your vote, it is also having your vote reduced by votes cast by ineligible voters. This bill doesn't target students. It addresses many areas of improvement I identified when working with the checklist to understand the voters in my town. New Hampshire does a good job, but we can still do better. Supervisors leave deceased residents on the checklist, relying on automatic 3-point matches from the Secretary of State, because they don't have clear authority to remove a voter based upon a partial match and obituaries. Out of compassion, they don't send the 30-day letter because it causes pain to the family of the deceased. But these voters at election time see their deceased family members on the checklist, and today they are told to wait for the 10-year update. The voter continues to see their loved one on the list, and they still get a letter to their dead loved one at the end of the decade. This bill fixes the problem for some of the voters, and it allows proactive family members to provide documentation and remove their dearly departed from the checklist. This bill's requirement to update the address file to reflect the postal standards will directly address several problems. It will prevent an address from being recognized as 10R Mulberry Lane and 10 Mulberry Lane Apartment R. This matters not just to prevent duplicate entries or to see if there are two multi-generational households still registered at the exact same address. And I saw both of these while working through the checklist in my town. This is critical for mail deliverability. You may hear testimony that the 10-year update results in many voters re-registering after their names are removed. Is that a problem with the system or a problem with the addresses? I believe that problems with addresses remove a significant number of eligible voters every 10 years. In my opinion, the address standards in this bill will over time reduce the workload for our supervisors and prevent removal based upon poorly expressed addresses. This brings us back to the idea of disenfranchisement. As members of the Election Law Committee, I expect that you are very familiar with the process of same-day registration and the flexibility we allow for voters who show up with no documentation. Knowing this, you should be confident that if an eligible voter is mistakenly removed from the checklist, the remedy is simple and immediate. It is our duty to keep the voter checklist as accurate as possible. This saves towns and cities money, as the polling location requirements are based upon the number of voters on the checklist. A bloated checklist has a very real and significant cost financially. Article 11 of the New Hampshire Constitution states, every inhabitant of the state 18 years of age and upward shall have an equal right to vote in any election. I ask if that vote is really equal if our checklist contains former inhabitants and grants the right to vote absentee to these ineligible voters. One vote means one vote. Every vote cast by an ineligible voter means that your vote counts for less than one whole vote. I ask for your support of this bill, and I am available for questions now or offline in order to support your work to pass this bill and ensure that every eligible voter casts one full vote. Thank you.
Questions from the committee? Seeing none, I believe we have other people on there, Kristen.
Yes, next I will bring in Representative Timothy Horgan.
Thank you very much. Hopefully I'm unmuted. So I'm Representative Timothy Horgan. I'm from Stratford County District 6, the towns of Durham and Madbury, and Durham is a college town, and we do actually do have a lot of our checklist do have a lot of voters who moved away, but they were inhabitants when they voted here. So I think first I think you probably should verify that the factual claims behind this bill are true. See how many people actually are sending in absentee ballots who've moved away and never come back. That should be something that probably the Secretary of State's office might have data on. So you might want to just make sure that's true before taking it as gospel. And anyway, there's a lot of, I just want to say briefly, I think this bill is, first of all, it's an unfunded mandate. The town and city, we're asking the town and city clerk to do a lot of investigation, and the town and city clerk's office currently don't have an investigative function. So they don't actually have investigators on staff. It's usually just the town clerk, the assistant clerk. It's not sure who's going to do all this investigation. In terms of the dead people on the checklist, I believe just the family can send in a note like saying that they've died and can be deleted. If there's a problem there, maybe that can be fixed. But I don't think we need. But I think this bill goes way too far. It's unnecessary. And like I said, it's an unfunded mandate. For example, it costs money to subscribe to the post office's database that they referred to. So that's I would say probably before you should. I think probably this bill isn't ready to be passed, or at least you need to probably investigate to see if the rationale given for it is actually valid, which I'm not sure it is. So that's about it. That's what I say. I just say, so I think you should probably at least not pass this bill right now. So it won't be ready to be passed by June 2nd, which is next time we in the House will be getting it back. So thanks.
Okay, are there questions from the committee? Seeing none, thank you, Representative. And Kristen?
All right, next we will bring in Marilyn Todd.
Hi, I just wanted to say that I think any bill that wants to clean up our voting rolls should absolutely be passed. I don't even think I think the town should automatically be doing it. I'm actually kind of sad that you guys have to make it a law to clean up the voting bills. So I don't think we should not bring this bill forward. I think New Hampshire is very, very, very needing as much, voting election integrity laws as we can possibly get. And I don't even think you guys should be having to do this, but if you guys have to make a law about it, then I think it absolutely needs to be put forward as soon as possible.
Okay, are there questions from the committee members? Seeing none, thank you. Do we have anyone else?
I have David Scanlon.
All right, Mr. Scanlon.
Thank you, Mr. Chairman and members of the committee. Once again, I'm David Scanlon, Deputy Secretary of State. And my testimony is going to be in general support of this legislation because much of what is contained in this bill are things that we are already doing. For example, when it comes to death record information, when Vital Records, which is a division within our office, receives death information that shows an exact match of a person who has passed away to a name that is on our voter checklist, that information is sent directly to the city or town clerk, who then passes that on to the supervisor of the checklist so that they can address cleaning up that portion of the list. Currently, if there is a partial match of the name of a deceased person and the name on the checklist, that information is not sent directly to the cities and towns, but the town clerks are instructed to go into Nevrin, which is the New Hampshire Vital Records Information Network, which the town clerks also have access to because they will deal with vital records, marriages, deaths, adoptions, births that happen in their community. They're actually an integral part of that process. So they have access to the death information that they can review and then pass on to the supervisor. And to that end, I'm looking at page 1 of the bill on line 8, where it actually this sentence suggests that the Secretary of State pass on partial information to the towns after this says an investigation. Instead of saying investigation, because I think that gets into the area of confusing what happens with the Attorney General's office. They're the ones that are authorized to conduct an investigation if a voter is suspected of inappropriate activity, in this case, maybe voting twice. So I think that language on line 8 should read matches for further, and instead of investigation, just put review and confirmation, because that's what the supervisors do. They review the information that they receive from whatever source to make a determination on whether the event has occurred, in this case, a death. And if they can confirm that, then they would take the appropriate action on cleaning up the checklist. And then moving on to page 2 of the bill, on line 11 starts paragraph subsection B. And before we get there, let me just address the section right above that where it instructs the database information of voters be compared with the United States Postal Service standard address. We actually would favor that. As Representative Horgan said, there is a cost, there's a subscription fee to receive the national change of address information from the U.S. Postal Service. But that is useful information in keeping the checklist up to date. And so that is something that, that we would favor, and I believe it would be useful to, for the supervisors of the checklist in the cities or towns to clean up the information. Moving on to the next paragraph, it starts on 11. That paragraph is confusing and from two standpoints. One is, as I mentioned, it's supervisors of the checklist that are responsible for keeping the checklist information clean. They're the only ones that are authorized to remove a name from the checklist or to add a name to the checklist. And so to the extent that the language in that paragraph suggests that that's something the town or city clerk ought to be doing, the reference ought to be changed to supervisors of the checklist. And then also we get into the use of the term investigation in there, that should be different. So I will be happy to pass on suggested changes to that, but let me just read the paragraph the way that I think would be appropriate. So starting on line 11, it should read, the Secretary of State shall provide for, and then I would add a verification process that voters sharing a place and date of birth along with a substantially similar name to include nicknames or likely maiden married name changes are unique voters. Should any voter appear to be a duplicate registration, information shall be forwarded to the city or town, and then I would add supervisors of the checklist where registered, and then I would say for review and confirmation instead of investigation. And then I would have the next sentence read, such clerks shall notify the Secretary of State of the result of such review. I said clerks, that should be supervisors of the checklist. And should the records, instead of investigation, show that a single individual may have voted more than once in any election, such information shall be forwarded to the Attorney General for further investigation or prosecution. And that is, that last part of that is the process now, where if clerks or supervisors through their work identify suspicious activity, then they do notify the Attorney General's office, who will follow up with an investigation and prosecution if that's warranted. That's the extent of my testimony, Mr. Chairman. I would be happy to answer any questions.
Do committee members have any questions? Senator Susie.
Yes, just one on page 2, Mr. Scanlon. That sentence that begins on line 8, the subscription. Is that something that the Secretary of State subscribes to currently? And would that be available for use by cities and towns? I am concerned about the additional cost and whether or not all cities and towns would subscribe.
We do not subscribe currently, although we have discussed it many times, but there is a financial commitment, and it's one of the reasons that has held us back. I should know what that number is, but I don't at the moment. I'd be happy to find that out for you and let you know what that annual fee would be.
That would be helpful. Thank you.
I do have a question to the Deputy Secretary. Is it possible that for those items that we would do that on a state basis, that one subscription at the state would suffice to be able to process that information?
Mr. Chairman, let me look into that. I'm not sure if the U.S. Postal Service would allow us to do that on one license, or whether each community would have to obtain their own subscription, but I will find that information out.
Okay, thank you very much. Additional questions? Seeing none, do we have anyone else on the list?
I have Lisa Matthews and Albert Todd signed up, but I do not see them on the list. We do have a hand from Fenton Groen.
Okay, Representative Gruen.
Hello, this is Representative Fenton Gruen, and thank you for hearing my testimony. Being on the House Election Law Committee, we heard this bill there. I do strongly support it, and having heard the suggestions of Deputy Secretary of State, I would fully support those changes. I was trying to figure out how to just note my support, but I couldn't find that on the page, on the Zoom page here. So I thought I'd raise my hand and indicate my support. Thank you.
All right. Thank you very much, Representative. Questions for the representative? Okay, is the sponsor of the bill still on the call?
She is, yes.
If you bring her back. Representative.
Thank you, Mr. Chair.
I'm sure that you heard the testimony from the Deputy Secretary. Would you care to comment?
Yes, thank you, Mr. Chair, and thank you, Deputy Secretary. I agree with all of the changes that were proposed by the Deputy Secretary. I think that they would improve it, and I apologize for the sloppiness in my language. In my investigation on the address change, I believe that there is a way to have the state sign up as a municipality, and there's already a process for that with the United States Postal Service. I'm not sure of the exact cost, as I wasn't able to get that information from the postal inspector. However, the other alternative to an annual subscription would be to be able to submit the list for a rather small amount per voter, which would be less than the cost of wasted stamps at the town level. Although I know that obviously they come from different parts of the budget, but I do support these proposed changes.
Okay, and the Deputy Secretary has said that he would investigate that for us. So any further information you have, Representative, if you provide it to not only the committee, but to the Deputy Secretary. Senator Birdsall, I see your hand.
Thank you. And thank you for coming on, Representative. I just want to, can you talk a little bit about who helped you put this piece of legislation together?
Thank you, Senator. That's a wonderful question. The seed for this legislation came from my work on the checklist, and I worked closely with the supervisor of the checklist, the town moderator, and the town clerk in Derry in order to better understand the process, what they already had to update the checklist and keep it up to date, what they were allowed by law to do, and what was in the gray area and they felt was not an appropriate use of their authority at this point. I also worked with a representative from Londonderry who worked with his town clerk, and that has their support as well. By checking that in 2 of the larger towns, it seemed that was a good way to look at this process, because in Derry, with the 10-year update, it takes them the better part of the year to send out all of the letters, and it is a huge cost and a huge burden in our town. So any changes to do this on an ongoing basis would prevent that big flood of effort every 10 years. And it should be able to reduce that every 10-year burden.
Follow up?
Yes, ma'am.
And Representative, were both the moderators in support of this bill?
Thank you, Senator. Yes, both moderators were in support of this bill.
Thank
It
you.
is actually many of the practices that Londonderry is going ahead and doing, but Derry would like to see this provided for in the law before they take those actions.
Thank you.
Senator Perkins Coca.
Yes, thank you, Chairman, and thank you, Representative, for taking my question. I'm concerned about some of the ongoing or additional costs that some of the other panelists have mentioned. So could you talk in a little more detail about why doing this on an ongoing basis in the view of the moderators and the clerks would save money as opposed to doing it every 10 years? I know other states do this electronically through, multi-state exchanges, but I want to make sure we really drill down on that here.
Thank you, Senator, for your question. The supervisors of the checklist have periodic meetings where they review any changes to the checklist, and part of their job is to do ongoing changes which are already provided for in the law and in their process. This would add a couple items to their tasks as they go through the year. However, it would make it so that the 10-year update is far less burdensome. In Derry, they can't even read enough names at one session to be able to send out all of the 30-day notices, and they need to do it in chunks so that they can provide for this. It is something that is a noticeable impact here in Derry, and while it may not be quite as noticeable at the 10-year point for some of the smaller towns, that just means that the ongoing maintenance would also be smaller. And I'm sorry if I missed part of that question. I have a toddler trying to get some snacks right now.
We understand.
I understand.
Follow up or anything, Senator?
No, thanks.
Okay. Seeing none, any other questions? All right, thank you. Do we have anyone's hand up now?
I have Marilyn Todd's hand raised for a second time.
All right. Ms. Todd, I
Hi.
do limit the amount of time you get on the second hand raise, so be quick and concise.
Yep, no, I will. I just want to let you guys all know that there is a lot of people that are willing to volunteer to do work like that. And, when I think about election integrity, I don't think money should be an object. I would rather my taxes go to, election integrity and making sure the elections are 100% accurate. And that goes, meeting the voter rolls. And a lot of time I'm hearing money, money, money. And I just don't think election integrity should be viewed at with a cost approach. I mean, I think the citizens of New Hampshire are really, tired of what's going on and no voter IDs and things like that. So I don't think money is an object. And I think cleaning up the voting rolls is going to be a huge part in, election integrity. And I think a lot of people would rather their taxes go to that.
Okay, thank you. Questions from senators? Seeing none, are we at the end of the hands now?
I do see a hand raised by Representative Erica Leon again. Oh,
We'll
she put
bring
it
her
down.
back
It must
on,
have been accident.
but it's got to be quick. This is 3.
I see she put her hand down. She must have raised it by accident. So we're all set. We have no more hands raised now.
All right, then we'll close the public hearing on this bill and start the public hearing on 484 as soon as staff is ready.
Must have been the toddler.
Could be.
It was a
Could be.
little hand.
Okay, if everyone's ready, we'll start the public hearing.
Thank you, Mr. Chairman. Am I audible?
Yes, you are.
Thank you. Thank you, Mr. Chairman, and thank you, honorable committee members. I appreciate the opportunity to introduce to you House Bill 484 relative to Budget Committee recommendations on warrant articles. For the record, I am Representative Diane Power. I represent the towns of Brookline and Mason in Hillsborough County, District 26. Presently, I serve on the House Municipal and County Government Committee, and I have also served as chair of a budget committee. This bill comes from requests by constituents. One constituent, in the course of conducting research on the behalf of a town study committee, discovered that budget committees in some municipalities are publishing recommendations on warrant articles that do not include appropriations or expenditures. Moreover, in a conversation with the New Hampshire Municipal Association about this very issue, the constituent was informed that New Hampshire law, in fact, does not authorize the inclusion of recommendations by a budget committee on non-money warrant articles. With that, allow me to introduce the bill. House Bill 484 simply clarifies that a budget committee or an advisory budget committee shall only provide a printed recommendation next to a warrant article that is monetary and includes an appropriation or an expenditure. As stated previously, it is common practice for some budget committees in New Hampshire to publish recommendations on non-monetary warrant articles. Examples of which include zoning amendments, a question to either adopt or rescind the SB2 system of town meeting, a question to print the tax impact next to warrant articles, establishing a study committee, etc. RSA 32 states that the purpose of a budget committee is to assist the voters in the prudent appropriation of public funds, and that the duties and authority of a budget committee are as follows. Number 1, to prepare the operating budget. 2, to conduct public budget hearings. 3, to forward copies of the final budget to both the clerk and the governing body. And 4, to provide recommendations upon special warrant articles to the governing body. And special warrant articles are defined in statute as any article in the warrant which proposes an appropriation. Therefore, according to statute, a budget committee should only provide recommendations on the following 2 items: the operating budget, which is an appropriation, and special warrant articles, which by definition include an appropriation. So to be clear, an appropriation is monetary. Thus, when a budget committee publishes a recommendation on non-monetary warrant articles, they do so outside of their statutory authority. In conclusion, this bill amends RSA 32 to make it explicit that a budget committee shall include a recommendation in the town, school district, or village warrant next to monetary warrant articles only in accordance with statute. And in doing so, this bill clarifies that a budget committee shall not provide recommendations on non-monetary warrant articles. Thank you, Mr. Chairman, and thank you, committee members, for your time and your attention. Mr.
Senator
Chairman, I'm
Birdsall.
happy to answer any questions.
Senator Birdsall has a question.
I do. Thank you, Representative, for coming on and presenting your bill. Just a question, because in our town in Hampstead a few years ago, I noticed in the bill it says, and I don't think this is any information that you changed, but it says on line 3, a budget committee or advisory budget committee shall provide a recommendation printed in the town school district. A few years ago, our superintendent would not allow our advisory budget committee to put a recommendation on the ballot to the operating budget. So it sounds like this piece of legislation has always said they shall be able to provide a recommendation on the ballot. Is that correct?
Thank you for the question, Senator Birdsell. The purpose of this legislation that's before you, the focus is on what type of warrant articles a budget committee is allowed in statute to provide a printed recommendation. And there's other parts of the RSA which address that. So to be clear, an official budget committee is permitted in statute to provide a recommendation. An unofficial budget committee, and in some municipalities, they're referred to as finance committees, they're advisory only. So therefore, if it's an advisory budget committee, then they're not permitted to provide a printed recommendation. That's my understanding.
Thank you.
Additional questions? Seeing none, thank you, Representative.
Thank you.
Okay, our next speaker is, let's see, Representative Norm Silver.
Thank you. Thank you, Mr. Chairman, and thank you, Senators. I'm in support of this bill, and I'm sure that many of the bills, if not most of the bills you hear, the proponents say, this is really very simple, or this is just a housekeeping measure. In this particular case, it really is very simple and is a housekeeping measure. The only statutory purpose of a budget committee is to assist the voters in the prudent appropriation of public funds. I was the chair of the budget committee in my town. I'm from Belknap District 2, which are the towns of Guilford and Meredith. And I served for a couple of years as chair of the budget committee in Guilford. The New Hampshire Municipal Association has stated, and it's on its website, that the budget committee recommendations should appear only on appropriation articles, and that the law does not authorize the inclusion of recommendations on non-monetary articles. This bill is designed to make it crystal clear, although it really shouldn't be necessary. The bill makes it crystal clear that a budget committee can only include a recommendation on a warrant article that contains an appropriation or an expenditure. The view of the proponents of the bill and of the House that passed it is that a budget committee should stay in its own lane and not utilize whatever prestige it might have to make recommendations on warrant articles outside of its specific authorized purposes, which is strictly to deal with appropriations and expenditures. So I urge your support of this bill. Thank you.
Questions from committee members? Seeing none, thank you very much, Representative.
Thank
you. Back to you, Chris.
Our next speaker is Representative Timothy Horgan.
Oh, thank you very much. My name continues to be Representative Timothy Horgan. I continue to be from Stratford County District 6, the towns of Durham and Madbury. My basic thing I want to say is basically the budget committee probably should be, sometimes does have valid reasons to make recommendations that don't directly involve an appropriation or an expenditure. And I'm not sure exactly how this bill would affect my town of Durham, which does not have a budget committee, we have a charter, so we have a town council whose duties are defined by the charter, and many other committees, but not a budget committee per se. So the town council actually is the budget committee. So that would create a conundrum if you tried to apply this law literally to the situation in my town, where that would effectively like cripple their ability to put out the town warrant. So at least you need to tweak that. It also says nothing about cities, but cities like a few towns, like cities all have charters, just like Durham and a few other towns have charters where the budget committee, if it exists at all, already has duties defined by the charter, which may come into conflict with this law. So I think this law is unnecessary. If the budget committee makes a recommendation that the voters don't like, well, so be it. And here at the state level, the finance committee, House and Senate finance committees are sort of our budget committees. And I think none of you are on the Senate Finance Committee this year, although I think Senator Susie was previous term. And you've all seen the bill, there's all kinds of things that are not related to appropriation expenditures in the hundreds of pages of bills that we sent you. And that's, I don't agree with all the recommendations the majority sent over, but that's a valid practice. And there probably are situations where that's a valid practice at the municipal level. So I would say this bill is unnecessary. If the budget committee makes a bad recommendation, the voters are free to reject it. I don't see why we need this bill. So that's what I had to say about this. Thanks.
Do committee members have any questions? Seeing none, do we have any hands left or people?
Our next speaker is Eric Power.
Mr. Power.
Yes, hello. My name is Eric Power. I'm from Brookline. I'm a former school board member that had a budget committee. And I recently served as the chair of a BudCom study committee for the town of Brookline that was chartered by our select board. And on that committee, we studied all about budget committees. That was our charter, to recommend them for our town to see if they made sense. So we got into a great bit of detail on RSA 32, understanding what a budget committee does and its fiduciary responsibilities in appropriating funds, as you've heard. A budget committee prepares and recommends an operating budget, conducts hearings, and delivers a budget. And the other important thing that they do is they provide recommendations on special warrant articles. And by definition in RSA, a special warrant article is an article that proposes an appropriation. So if there's a warrant article that doesn't have an appropriation, the budget committee shouldn't be providing a recommendation. And we reached out to New Hampshire Municipal Association and confirmed this practice. They said that the law did not authorize such recommendations on non-monetary warrant articles. And it's also consistent with their published guidance on their website. And in our course of our work, we spoke to budget committees across the state, and we found varied practices in this area. Some decided that they could weigh in on any warrant article, and some basically stayed in their lane and followed the guidance of New Hampshire Municipal Association. We found that some budget committees felt like it was appropriate to weigh in on warrant articles such as changing the size of a select board or a school board, establish a study committee that didn't have an appropriation, provide curriculum directives in a school district, and adopt or rescind the SB2 official balloting system. None of these really are in the lane of the budget committee, but budget committees are recommending them nevertheless. What we found is that what's happening is that it seems like the budget committees and their recommendations are personality driven by the local politics and the people serving on the board deciding which warrant articles they should be weighing in on instead of following the law. And this also comes from our discussions with these budget committees and other budget committees, as well as my experience on the school board that had a budget committee. Some budget committees act like they think they're a second governing body, and that's how they should make their recommendations. So currently, the language of RSA 32 does not provide enough clarity to keep a budget committee from making recommendations on non-monetary warrant articles, despite the guidance from New Hampshire Municipal Association and common practice. This House Bill 484 provides the needed clarification to RSA RSA 32 language so that BudCom only provides recommendations on monetary warrant articles in the warrant, consistent with their fiduciary responsibilities and authorities. It's really a housekeeping bill to make some clarity. This bill proposed language makes it clear that warrant articles involving policy and governance issues receive recommendations from the governing body and not from a budget committee. Thank you for your consideration, and I request that committee members vote ought to pass on House Bill 484. Thank you.
Questions from the committee? I do have a question. In some of your examples, there are budgetary implications on some of the things you listed, like the number of selectmen. Selectmen usually receive some kind of a stipends. And so that does have some budgetary implications. If I also change my form of government from SB2 or back from a SB2, there are budgetary implications there on conducting the elections and how different things are. Is it, how do I measure what this bill says against what would or wouldn't be the policy for those, and I'll say budget adjacent items, for lack of a better term?
Yes, that's a good question. I guess the distinction is that some of the appropriate articles that have appropriations and expenditures have dollar figures and they're very quantifiable. You can argue that almost any warrant article eventually will have some tax impact at some point in the future. But that's where you have to draw the line between what a budget committee has authority to do, in terms of what RSA 32 says the intent of a budget committee is in the appropriation of public funds. There are going to be some warrant articles like, if you have more selectmen, you will maybe have a little bit more for stipends. If there's less selectmen, you might have less, but it's still, it's not an appropriation directly. And that's the purpose of this bill. By clarifying the bill clarifies the language to make it clear where the budget committee should be recommendations, where they shouldn't. The one that really comes out is the SB2 system. Why should a budget committee be weighing in on adopting SB2 or rescinding SB2? Will there be a tax impact? Maybe, maybe not. But you have to, it's really a governance question. And that's where the school board or the select board should be making the recommendations and not a budget committee.
And follow up from myself here. The thing is that how do I draw the line? In the bill, the language proposed says includes an appropriation or expenditure. Okay, so going back to the selectmen, I am actually changing an expenditure, by doing that. I would think that if we're going to leave this in there, then we should tighten up the language somehow to make it more clear what the author is trying to get, or we'll be back in the same situation we are now. Comment?
Sure. I mean, I think when you're crafting the warrant article, you should, whether it's petition or it's the governing body, if they clarify, for example, in the select board or school board changing the size, they put in the warrant article the stipends, then that would make it a monetary warrant article, because then you would be clarifying what the amount is. But if you're silent on that, you're leaving it up to the governing body to determine that. And so I think that's how you would address it. I think warrant articles need to be clear to the public, because the public wants to know how much things are going to cost. And when they're nebulous and they don't have dollar figures, then that's where you get into challenges, I believe. People aren't sure how much things are going to cost. So this language would also make governing bodies and citizens petitions be more clear in how much they're appropriating when they're putting together a warrant article.
Okay, thank you. Do we have any other hands?
I have one last speaker signed up, and it's Cordell Johnston.
Mr. Johnson.
Thank you, Mr. Chairman. Cordell Johnston, representing the New Hampshire Municipal Association. And I did not indicate any position on this bill. I think it is, to some extent, essentially a housekeeping bill, or maybe not housekeeping, but more of a clarification. The existing statute authorizes budget committees to make recommendations on special warrant articles. And it is and has long been the interpretation of the municipal association that it is limited to appropriations. There can be, as you've indicated, Mr. Chair, situations where a warrant article will have an effect on town expenses. And I can understand that some people would see that as something that the budget committee ought to be weighing in on. But it gets pretty ambiguous, because really, I suppose almost any action taken by the town can have some kind of budget impact, maybe not this year or next year, but eventually. So I do think it is within, it is the role of the budget committee to be making recommendations only on things that include an appropriation or an expenditure. And I think this is essentially a clarification of what they already should be limiting their recommendations to. So, as I said, we're not advocating for the bill, but I think to the extent that the law needs to be clarified, it may not be a bad idea. Clearly, a budget committee should not be issuing a recommendation on zoning amendments or on adoption of SB2. That really is not their responsibility. So that's real. One of the speakers, Representative Horgan, raised the question of how it would apply to Durham and to cities. I think the answer is it doesn't, because RSA 32 is for towns and districts that adopt their budget at an annual meeting of the voters, which cities do not. And Durham, as a town council town, I believe does not have an annual meeting. That the budget there is adopted by the town council. So I don't think it would apply there at all. I'd be happy to answer questions.
Questions from the committee? Okay, Cordell, if you and the prime sponsor would get together and at least talk over my concerns on how we would put language in there that would clarify what they can and cannot comment on, I would appreciate that. Certainly, I would have no problem with them putting a note next to an item that would say, if you add a selectman, they get $1,000 a year, so it's $1,000 increase in such and such a line item. But again, I'll let you two talk about that and get back to the committee. We will not exec this for at least a week. So,
okay.
Other comments or anything from the committee? Okay, seeing none. We'll see if anybody wants to put their hand up, I guess.
If anyone else would like to speak on House Bill 484, please raise your hand now. And I'm not seeing any hands, Senator.
Okay, we'll close the public hearing on this bill and open the public hearing on House Bill 183 as soon as everyone's ready.
And our prime sponsor is Representative True.
Good morning. I'm coming out loud and clear.
Yes, you are.
Good morning, Mr. Chair and Senators. For the record, I am Representative Chris True, Rockingham District 4, with the towns of Auburn, Chester, and Sandown. Thank you for this opportunity to introduce House Bill 183, a bill prohibiting municipalities from requiring a license for a soft drink stand operated by a person under the age of 18. Please allow me to begin with those 4 words you all want to hear. I will be brief. As first introduced, House Bill 183 spoke of lemonade stands, and as amended and now before your committee, it has been broadened and speaks of soft drink stands. As you know, New Hampshire is a Dillon rule state, and as such, the towns are only to act within the authority given to them by the state of New Hampshire. I am asking for your support of House Bill 183 so that before any town acts to license a child's drink stand, this bill is passed into law so it is clearly stated that towns do not have that authority. I cannot find any compelling interest for a town to regulate and license a child's lemonade stand or a soft drink stand that they've set up on their front lawn. I have spoken to many of my friends and neighbors, and I agree with them when they say that they do not see any reason for the government to interfere with a child's drink stand. I realize this bill is probably not the most earth-shattering subject that you've dealt with this year. Perhaps it isn't even the most impactful bill you've dealt with today. However, I feel the bill is making a very important statement. That is, there are areas in our lives and in our children's lives which are not the concern of government. I view House Bill 183 as a very simple bill and a very positive bill. And I thank you for your time and for your consideration.
Questions? I do have one. In your testimony, Representative, you talked about on their front lawn, okay? The bill right now does not talk about where. It says that the village district, city, town, or village district shall, let's see, let me try to get the words correct here, about prohibiting licensing or regulating soft drink stands operated by a person under. So if I read this, the way I could, if I want to set up a soft drink stand down on the Rochester Commons or right there next to Parson Main statute here in Rochester, that the city couldn't stop the person from doing that if they were under 18. Is that right?
Thank you, Senator. I believe the city would certainly have a compelling interest if a lemonade stand was set up at a dangerous intersection or a dangerous area of construction or whatever. I don't see, looking back into my past and the lemonade stands I set up when I was a kid, I don't see parents sending their kids to some other area of the city to set up a lemonade stand. That certainly would not make any sense. And if it was set up without parental assistance and guidance and into an unsafe area, well, that's an entirely different issue. That children are not safe where they're set up.
Okay, Senator Ward. Senator Ward, we cannot hear you, Senator.
You may be blessed not to have to listen. I have 2 amendments to this bill, and I'm just curious which one is the appropriate one. One is 0029 and the other one is 0092.
I believe that 92 is the one passed by the House. but we will check on that.
Follow up? That one doesn't have a effective date on it, 9/2.
Because it does the modification. The actual 9/2 says effective date shall be 60 days after passage on line 17. If you go into your the Senate page and type in House Bill 183, and you click on the PDF form, you should get the version which is 9 April 2021 ... 0092H.
Yeah.
Okay, I'll do that when we finish, because I'm not sitting here with two computers.
Representative True? Representative True?
Yes, sir. Yes.
So I take it you would not object to a modification to this to talk about lemonade stands operated on private property with the permission of the owner.
No objection at all, Mr. Chair. None, no.
All right. Who is next on the list? Thank you, Representative.
Thank you.
Next, we have Representative Tim Horgan.
Thank you very much, Mr. Chair. So I continue to be Representative Timothy Horgan from Stratford County District 6. And so this is the third and final time you hear from me. All these bills passed the House pretty much on party lines, and I am on the minority party, but I'm just speaking for myself rather than for the caucus as a whole. So they've, this bill is a, well, to use one of our favorite expressions, it's a solution in search of a problem. So a few years ago, sort of there was kind of like this meme going around about kids being prosecuted for operating unlicensed lemonade stands on their front lawns and so forth. And that was there's actually no evidence that there's little or any of this actually happening. The only solidly documented case was a girl in London, England, who was fined the equivalent of $200 for operating a lemonade stand somewhere in London. That's like not even in the United States. And there's a few scattered cases elsewhere in the United States, but this has never happened in New Hampshire. So neither lemonade nor other soft drink stands. The amendment, I think, came about because a lot of us were so enthusiastic about the bill, and or the sort of joke like, and it failed once last year, was that if the kids can only sell lemonade, why can't they sell other beverages? So the sponsors cooperated with this time and like put an amendment in allowing other beverages, and that makes in my view the bill even more problematic. As I said, it as it came over from the House, it basically says an 18-year-old can sell like soft drinks with no regulation whatsoever. The state, I think, probably sometimes does have a compelling interest in regulating sales of soft drinks. There are health issues and other issues which can arise. And also this seems like you could have like an adult could have a minor as the front person for their unregulated soft drink selling business. So this is and also something else which made this a nationwide issue is just Kraft Foods, who rate Country Time Lemonade, did sort of a publicity stunt in 2019 where they would offer legal assistance to any family whose children were prosecuted for operating illegal lemonade stands, preferably with Country Time Lemonade. And I don't think any families need to avail themselves of the legal aid, but that was so partially this was caused by a publicity campaign by one of the major manufacturers of lemonade. So this is so I think you're probably, certainly the kid wants to put a lemonade on their in front of their house. That's, I don't think anybody has an objection to that. And as far as I can tell, no one in New Hampshire, no family in New Hampshire has ever gotten in trouble for doing that. So, but I think, and I think this bill is unnecessary. So that's a good enough reason right there to certainly kill it. If you want to have an amendment that clarifies that it actually is just a lemonade stand, which can sell other flavors of sugary beverages on the front lawn, that would be fine too. I certainly, I'm not going to be on the committee of conference probably, but I'm sure that could probably pass the committee conference process. So anyway, I think this is unnecessary, and you certainly shouldn't go forward with it in its current form. And you did. I've got the printout in front of me. It's a little bit confusing. The original LSR was indeed LSR 21-0029, and then the amendment was LSR number was 0092. So I don't know, one of those funny things that happens with LSRs. So that's anyways, I say this bill. Yes, I'm against this bill.
Senator Birdsell has a question.
Oh, sure.
Thank you for taking my question, Representative. Are you aware that in 2019, May of 2019, that the New York police shut down a 7-year-old's lemonade stand? And in 2011, a 12-year-old's green tea stand was shut down just next door in Massachusetts?
Well, those aren't in New Hampshire. Certainly, I mean, there is a larger issue here of police overreacting to minor issues, and that those may have been bad cases. I mean, there are a few scattered cases, but there isn't really a pattern here in New Hampshire of police oppressing people who are operating unlicensed lemonade stands. But I mean, I certainly do appreciate the
Senator
police have a lot of.
Has a follow-up, Representative.
Yeah, thanks.
Well, just in your opening, you said that there were no cases except for one in London. I just wanted to make sure that you do have some in the
That
US.
was the most solidly documented one I could find where somebody actually had a significant penalties, and that's one that is often cited as a reason why we need this legislation. That was not even in the United States. And there's a few scattered things. I also did see a news story about Newburgh, New York, although then the police actually ended up operating the lemonade stand alongside the kids. I think they set it up on a corner, which was kind of blocking traffic or something. But that's but there's not a and I guess I certainly do appreciate that thing with the police overreacting all kinds of minor offenses, including operating unlicensed lemonade stands. So that from that standpoint, the bill may not necessarily be a bad idea, but just this specific bill, I think, tackles a problem that's virtually non-existent and certainly not in any way specific to New Hampshire.
Okay, Representative, we're starting to get repetitive here.
Okay, well, that happens. Sorry.
Are there any other questions from the senators? All right. Thank you very much. Thank you, Representative.
Thank you.
Who's left on the list? Kirsten.
Next, we have Nancy Vaughn.
Ms. Vaughn.
Yes, good morning. For the Chairman Gray, members of the committee, for the record, I'm Nancy Vaughn, Government Relations Director for the American Heart Association. And I come before you today providing testimony in opposition to House Bill 183. The American Heart Association opposes state government removing local government authority and make decisions on issues impacting their communities. When states block local governments from passing laws that make sense to the community, our concern is it can hurt people the most where the need is greatest. In other words, one size fits all rules don't necessarily make sense for all communities. Local governments, as we know, are uniquely positioned to meet the needs of people in their communities. They're very connected to the residents and very accountable to them. Residents and local leaders not only want what's best for their communities, they know how to solve local problems because they see them up close. And when a local community comes up with a solution for a real challenge and residents work together to put into practice a solution, the state government should really support that and not strike it down. Now, states should provide the foundation to build on, basic protections for communities, but then allow those communities to strengthen those protections as opposed to take away all authority to make any of those decisions. You know, should a community find a situation arise, whether it's with a soft drink stand or anything else, without local decision-making authority, municipalities would need to appeal to the legislature to act on issues that could be remedied directly and much more expediently locally. For these reasons, I urge you to vote inexpedient to legislate on House Bill 183 and protects New Hampshire's tradition of local control. You know, beyond this issue, we see any attempt to remove local control from communities as something that really can create a slippery slope for more controls down the line. And you know, I was thinking particularly for this issue of that very point, Senator Gray, that you brought up. And I think the only time that we would see an issue on youth beverage stands in communities would be if the community had busy roadways. And we were seeing a lot of youth stands being put up on busy roadways. It's not just a safety issue for the youth, but it could be a safety issue for motorists on that roadway. It could be a safety issue for bicyclists where the motorists are being distracted. So again, all in all, the state governments, higher levels of government should not limit lower levels of government, because that's where decision making really does impact residents with the issues that they see before them. So again, please do not pass this piece of legislation. And if you have any questions, I'm happy to try to answer them.
Questions from committee members? Seeing none, thank you very much, Vaughn. And
thank you.
Whom else is on our list?
Next is Cordell Johnston.
Mr. Johnson.
Thank you, Mr. Chairman. Cordell Johnston, representing the New Hampshire Municipal Association, opposed to the bill. The one thing that I guess I agree with the sponsor on is that this is not the most important thing that you have to deal with. And I almost don't even want to testify on it, but feel that I need to. Even the supporters of the bill in the House committee stated that this was a solution looking for a problem. And the sponsor at the House hearing indicated that he had asked OLS to research whether this had ever been an issue, and it has never come up in New Hampshire. And it probably never will. So our concern is the state telling towns not to do something that they weren't going to do anyway. It's almost kind of insulting to tell local governments don't do stupid things. I think we know that municipalities are not going to try to regulate kids' lemonade stands or soft drink stands. It may have happened in a couple other states, but dumb things happen in other states. It's clearly unnecessary here. And I guess, as you indicated, Mr. Chairman, the only time it would happen is if kids are doing something that is clearly unsafe. And then the police or whoever should be able to come along and say, you know, move your lemonade stand away from this busy street. So the bill is unnecessary, and I think it represents a bad approach of trying to lecture municipalities about things they shouldn't be doing. If you feel that something needs to be done, at the very least, it ought to be made clear that it would not prevent municipalities from taking action that's necessary in the interest of either public safety or the safety of the children themselves. I'll leave it at that and am happy to answer any questions.
Any questions from committee members? Okay, seeing none. Do we have anyone else out there that wants to raise their hand?
I do have Shannon Bouchard sign up. I do not have her on this call. So if anyone else would like to speak on the bill at this time, please raise your hand now. And I'm not seeing any other hands, Senator.
Okay, we'll close the public hearing and move on to our next bill as soon as staff is ready, which is House Bill 243.
All right, and we have Representative Piemonte here.
Thank you, Mr. Chairman. And thank you for allowing me to have you review this bill. This bill, which requires transparency, it develops a more efficient budget. And many budgets many budget members have experienced problems obtaining timely and useful budget information in the live spreadsheet form. And having an active spreadsheet will allow members to immediately see the impact of increases and decreases in line items. And additionally, it will allow for year-to-year analysis on budgetary items, as well as time calculations during that budgetary process. As the budgets rise, it's impossible to do this adequately when provided with a PDF file to come to a conclusion. And sub-accounts really have to be analyzed in order to be able to do this effectively. This legislation will assist budget committees, school boards in completing their fiduciary duties. And I would like to have an ought to pass amendment if I could do that with. And that's, I'll take any questions if anybody has them.
Questions from committee members? Senator Susie.
Are you offering an amendment, Representative Piemonte? You said you wanted an amendment.
Well, I would be willing to work with, I'm sorry.
I don't believe the committee is in receipt of one. At least I wasn't aware. Is there an amendment that you're submitting?
No, there is it has an amendment attached to it.
Oh, okay. That the House already
That's what I was
voted.
referring to, correct.
Okay.
Yep.
Thank you.
I mean, and I'm willing to work with any of the senators if they want to like to consider to improve the clarity of House Bill 243. But again, I think it's a necessary tool that will help newcomers, and it will also give a view to the taxpayers of what may come up in their budgets.
All right, seeing no other questions from the senators, I do have a question. The representative and I had conversations about this bill over the weekend where I questioned what the meaning of full line item detail is. Since that's not in the definition, Representative, if you'd at least talk to that a little bit and about our conversation or whatever you think is appropriate in defining what full line item detail is.
Okay, the full line item detail is it really basically all the budget lines used to create that complete budget. I know budgets are they're amassed with many lines, and a lot of them are not used. But the ones that are used for the budget are sub-accounts, and they show valuable information and can be analyzed more closely year over year to any increases in inflation and things of that nature. Also, we have, certain things that come up that are guaranteed to the unions and the people that have raises for automatically each year. So they can be analyzed in that respect. Like I say, sub-accounts, we did talk about sub-accounts. And I think that was a good discussion we had on that.
Am I correct in saying that we talked about the MS 737 or 636 or whatever the appropriate form for DRA is, and the uniform chart of accounts, and that like the 737 lists police, lists fire, and that in some communities that it would be appropriate to only list the police and fire, but in others it would be those categories should be broken down into the number, personnel costs for police, vehicles, and other items, and that is what you're referring to when you talk about a sub account.
Yes, sir. And the MS forms, they deal with total numbers of those accounts in that file that they sent to the DRA. So, and I just would like to see a further breakdown in that area for those reasons.
Okay, thank you, Representative. Has that generated any questions from the rest of the senators? Senator Susie.
Actually, it does. Have you ever requested this information of a town and been denied the information?
Yes, well, there have been, that's what actually formulated this to begin with. 2 years ago in the last biennium, I put another bill similar to this in, and basically it would, it's not so much, I come from Sandown, and it's not so much their town. They do a great job. As a matter of fact, one of the Board of Selectmen wanted this downloaded to a thumb drive that he could use while they operated the meetings. And he claimed it was extremely efficient for him because it gave them immediate increase and decreases and what could happen for those particular items. But there were instances, and what culminated this was a person would like to see these sub-accounts, and they took a vote, and the majority said, well, no, we don't want that. Say the majority vote was like 5-1. That one person that was disallowed that, it was unfortunate. She never got to see it. Had a request, a right to know request in order to get any of that information. By the time that happened, it was too late. Our public hearing was already in process, and it was not efficient. This allows them to, if they request that, they can get it. Both governing bodies and taxpayers. So, some people work as accountants and they don't get home to make the meetings, but they can participate through email or suggestions that they may have to the committee and with this tool.
Further question, if I may, Mr. Chairman?
Absolutely.
But in a community, I'm just trying to assess how much added work is involved. So in a city like Manchester that has multiple departments, we're talking about personnel. We have more than 200 police officers, more than 200 firefighters, more than 1,000 teachers. That kind of detail could be crippling to a finance office. So, and never mind the cost. I mean, if the issue is to try to reduce cost, I think the amount of detail being requested could have the reverse impact.
Thank you, Senator Susie, for the question. They have the ability to do that now. And I had a computer software engineer testify in the committee, and it's basically a touch of a key. They have the ability to download that budget into a thumb drive, and off they go. There is no major cost, he determined, involved with this. People will use certain line items as needed for certain situations. Say, for example, the police in Manchester would like to have a few vehicles or a new vehicle. It may be time for them to come in, and they have a huge line item on purchasing of that or leasing of that. That can be broken down to see why it would happen to be that way. And justifiably be, adopted. So.
Okay. Senator Gray, we can't hear you.
Let me break in for a second and ask a question that I think may help you get to what you want, Senator Susie. Representative, is it true that you're not trying to make them do anything that they're not currently doing, but if they do break down one of these categories, such as police, into personnel, vehicles, and other things, that information that they use for either budgeting or tracking expenses be available to the public?
Absolutely. That's exactly what I'm looking to do with this.
Did that help at all, Senator Susie?
Well, no, because the language starting on line 5 says all municipal, district, and school administrative unit budgets shall use a line item detail. So to the extent that detail doesn't exist, if we're now mandating them to make it exist, it could, as I said, create a lot more added work than is there now. I mean, if somebody wants to dig into a line, sure, but the entire budget could be substantial.
I agree with you the way the words are right now, Senator, that they do not portray what the representative was trying to get at, in the final bill. But if we do make a modification to this bill that talked about sub categories and sub accounts, and only required that they have available the ones that they use to either budget or to track expenses, that I think it gets to what he's talking about and also protects the town about, in trying to provide additional information that's not required. But we can talk more about that when we get into executive session. So,
Sure.
And I'm sure we've got plenty of other people who would like to testify on this. Are there any additional questions for the representative? Seeing none, thank you very much, Representative.
Thank you, Mr. Chairman, and thank you, committee. Appreciate that.
All right, and our next speaker is Laura Bono.
Thank you. Can you hear me?
Yes, we can.
Okay, thank you. I am testifying in opposition of House Bill 243. I have a very nice thing typed up, and as I was listening to the representative, I couldn't help but feel that this is really a right to know law problem in these few communities versus a problem for all municipalities, which would require legislation. We already have, and I work for the town of Hillsborough. I'm the town administrator. I've got over 25 years of municipal experience between town administration. I've served as a selectman, finance committee member, moderator, et cetera. And I've been an integral part of budget processes for 4 municipalities, Ware, Hampstead, Warner, and Hillsborough. And I have a spreadsheet that is always being changed right up until before the hearing. And part of this legislation requires us to publish the budget 30 days prior to a public hearing. And if you've ever been part of a budget process for a municipality, you know that a lot of changes are made in those 30 days. We're getting final numbers in, we're tightening up line items because we want to make sure we have the best budget that we're presenting. So to say that we have to do this and make sure that what we have done is posted 30 days, I'm taking as we can't make any changes after that until we discuss it at the public hearing, which then creates the Department of Revenue form that would have to be updated. Of course, it's going to have to be anyway, but if you have numbers that are as close to final as you can get them when you're going into the public hearing, it's helpful. There's a whole process after that public hearing. You've got town report that you've got deadlines to get out. You've got various other locations you've got to put these new numbers in. And it could possibly create more confusion at that public hearing for the public who's got a 30-day-old budget and you've got updates. Most of them are usually minor at the public hearing. Furthermore, whenever you have a document that you're using in a municipality, whether it be notes for minutes or spreadsheets or printouts from your payables and payroll, those show all these detail that you're putting in. That's all available to the public. It's available to the budget committee members. They can, at least we don't have a budget committee in Hillsborough, but budget committees that I've worked with, they have the spreadsheet that I've used, and I've taken that same spreadsheet to each community because it works well and it's easy to manipulate in a positive way. So they can have that on their computer. They can make changes to it to see what it would do if they cut this line item or if they added to that line item. And in each department, it is detailed. And every community, you can't just have a lump sum, which is the Department of Revenue form. We get that lump sum by adding our details together. So I think I'm repeating myself now because I've gone off my script. But I think that this is more of I don't think the state should be micromanaging what municipalities use for their budget process. The right to know law is there. If communities are not receiving the information they're requesting, that's a completely different problem. And I think I'm going to stop there because I don't want to continue to repeat myself.
Okay, questions from committee members? I do have a question. In the communities that you've worked with, there is a requirement for the annual report to contain the MS 737 or 636. Is that normally what is presented at the town meeting, that level of detail?
No, my practice is to always have the detailed spreadsheet available. They have their town report at town meeting. 2 of those communities were Senate Bill 2. I've always had the detailed spreadsheets at the public hearing, at the town meeting, and available for anyone who wanted it. So there's
to follow up on that, the law says posted with the warrant. What is posted with the warrant? And I'm assuming that in most communities that is the annual report, which does contain only the MS 737 and not your detailed spreadsheet.
Right. What we're required to post, the Department of Revenue requires us to use theirs, which is the 636 for me, along with our warrant. So that is what gets posted at the voting site as well as at the town office. But we do post our detailed spreadsheet on our website for the public.
Excellent. That's all the questions I have. Any other questions generated by the senators? Okay, thank you very much.
Thank you.
Our next person is?
Our next speaker is Christina Barrett.
Barrett.
Committee, I think, as you know, it Barrett Christina from the New Hampshire School Boards Association. I take no offense. It happens all the time. It's not the first time that's happened. It's not the last time it's happened. I like to joke that if I had $1 for every time that happened, I'd be able to solve the school funding crisis in New Hampshire. So anyway, thank you, Chairman Gray and members of the committee. Barrett Christina, Executive Director of the New Hampshire School Boards Association, and we are opposed to House Bill 243. I'm going to start off with the language, in the italic and bold language on lines 5 through 8 about the full line item detail. In preparation for this hearing, I jumped online and grabbed some budget documents from the school districts in the respective communities from the members of this committee. And, you know, I understand that RSA 32 does not apply to cities. I did pull up Manchester, Rochester, Portsmouth, and Dover budgets. The Dover budget is 79 pages long, subline item after subline item, significant detail. For comparison, I pulled the Barrington School District, a town, 52 pages of again, subline item. Manchester document is 100 pages long, replete with line items after line items after line items. The Wyndhams, I believe I'm in Wyndham now. The town of Wyndham, I believe this was about 30 or 35 pages of significant subline items. What document am I on now? This may be Portsmouth, 73 pages. Rochester, I think I'm in Rochester, about 149 pages. So I think you get the point, though. Most communities and school districts are already providing this information to members of the public. But one of the other concerning languages about the language on line 5 through 7, right now we know that RSA 32 does not apply to cities, but Senator Susi, I believe you brought this up. The language says all school administrative units shall use this. So are we then applying provisions of RSA 32 to cities? And if so, what is the remainder? Does the remainder of just, this bill apply to cities, or does the totality of RSA 32 apply to cities? I know that's certainly not the intent, but that's the way the language reads right now. Moving on page 1, line 20 through 23 or 24, as NHSBA reads the language about but no fewer than 30 days prior to the hearing for its budget, we don't interpret that as meaning that the draft budget has to be provided 30 days before the hearing, because that's inserted into RSA 32.4, which talks about department heads having to provide to the governing body their estimated budgets. So in a school, that would be your building level principals, your special education director, maybe your IT department. But the reality is they're getting those budget numbers to the governing body months ahead of time, not just 30 days. Over the summer, superintendents and building level principals will begin draft budget processes, and usually right after Labor Day, school boards do the deep dive into their budgets and preparations for next March's annual meeting. So that language is not necessary. The language in the sentence on line 21 through 22, perhaps I'm misreading it, but it doesn't make sense to me. It begins, the governing body shall publish the draft budget and revised versions within 5 days. Within 5 days of what? That clause in the middle, you could, for the purposes of interpreting the sentence, I don't know what that means. The governing body shall publish the draft budget and revised versions within 5 days. Again, I don't know what that means, within 5 days of what. The other aspect relative to revised versions of the budget, you may have dozens, if not hundreds, of revised budgets. The superintendent and the business administrator may get together at 8 o'clock in the morning and work on the budget for 2 hours, and then save that draft and revisit it at 3 o'clock in the afternoon. Or the business administrator may take it home with him and work on the budget while he's watching the Red Sox game. So you're talking about, dozens, if not hundreds, of draft budgets. So I'm not sure if they would all have to be made available or just the final draft budget. But I think that's problematic in how it's written and how it would be implemented or interpreted in the field. And last, on page 2 of the bill, this is talking about municipal budget committees, where it says that the governing body shall provide information to the municipal budget committee so the municipal budget committee can fulfill their responsibilities with respect to the budget. And it says that they shall provide information at such times and in such detail as the budget committee shall fix. I think this is a communication problem, perhaps in local communities between the school board and the budget committee. when we do our budget workshops every year in the fall, we advise our school boards you have to have a positive working relationship with the budget committee. Sit down with them ahead of budget season and say, how can we establish a process for what the budget committee wants? Who's going to be the point of contact for the budget committee? Is there going to be a specified liaison? Can we schedule out meetings 3 or 4 months in advance so you're not calling the business office at 4 o'clock in the afternoon asking for documents that need to be prepared for a budget hearing in another hour? So, that may get us, a little bit further down the road. In some communities it may not, but I think that in such detailed language, ideally should be worked out ahead of time. Hopefully that there's at least a cordial and professional working relationship between the budget committee and the school board. So those are NHSBA's concerns with the bill. Again, we are opposed to it, and I'm happy to answer any questions that the committee may have.
Okay, questions from committee members? I do have a couple of questions. If we take and strip out all the added language in the bill, then go in and talk about, and what you called sub-line items, I'm trying to call sub-account level information, referring back to the Uniform Chart of Accounts, which is put out by DRA.
Right.
Would you have an objection to the bill saying that whatever sub-account level information that was used to develop the budget or track expenses be available to the public for inspection?
Sure. Thank you very much for the question, Senator. Indeed, I think that information should be made available to the public for inspection. The question then would be whether or not that is the information that's going to be posted, if you will, with the warrant and the budget. I think the best practice is to, in the interest of transparency, especially fiscal transparency, is to do what the provide documentation as the school districts and school boards that I mentioned, are doing. And I think that's the practice in most cases. One of, I think, the challenges might be is that the DRA forms do not require those sub accounts or those sub line items. So we may want to have somebody from the Department of Revenue Administration talk about perhaps maybe expanding their forms.
I did ask the DRA to have someone, but I didn't send that email out until Friday. So I don't know if it got there in time. But again, the law right now pretty much tells you that you need to post your MS in whatever it is, 737, 636, 6A,
Right.
there's a couple others there. And that would be posted with the warrant. But for those individuals who apparently stay up late at night worrying about the details underneath the items in those reports, if the bill were changed only to say that if you use sub-accounts, that you should have a spreadsheet or some way of providing that information, you would not object to that.
No, I don't. I mean, I certainly would want to see language ahead of time, Senator, as I'm sure you can appreciate. But yes, if there's a way to come up with language that would, suggest that more line items, sub-accounts, sub-line items, whatever we're going to phrase them as, need to be made to the public, I don't think NHSBA would have any objection to that. I mean, we see that districts are already able to do that. Municipalities are able to do that in some circumstances.
Okay. Would you believe that when I checked out Farmington, Sandown, and Milford, that the information that I found was inconsistent at best, and in at least two of those communities, only the MS report was available online for the voters?
I would believe that, Senator, yes.
All right. Any other questions? Okay, moving on to our next person. Thank you.
Thank you, sir.
Right. And I apologize again, Mr. Christina, for the mix-up.
Quite all right. Quite all right.
Our next speaker is Joe Devine.
Mr. Devine.
Good morning. How is everyone today?
Good.
Thank you, Mr. Chairman, fellow senators. I'm going to kind of echo a little bit what Laura already presented. She did a great job. but I'm Joe Devine, the town administrator for the town of Henniker. I do have some concerns, and I am in opposition of House Bill 243. This specific bill does require municipalities to take numerous undefined actions in our budget, in my opinion. It's my opinion that states shouldn't be micromanaging how our budget's prepared. And I should add, the state budget is not required to provide their budget in the same manner as being presented right now that you're asking for the towns to do. I am concerned with the phrase full line item detail, and I want to thank Chairman Gray for asking this question. I believe most towns do provide full line item details as described in the definition the representative requesting. My concern is some towns may use software that doesn't easily convert into an Excel spreadsheet or into a CSV format, which would make it difficult for a small community to get that information readily available. Also, while we're looking at definitions of this bill, I have concerns with it referring to as published. We know what published means as far as with the warrant goes and with the MS 636. Are we talking about the same thing? I'm assuming published in this situation means on our website, which is easy enough for cities and larger communities to do. But if you do have a smaller town, this is going to be a challenge. We could have staffing issues. We don't all have personnel at our beck and call that are dealing with networks and our websites. And other towns may not even have a website that they're posting at. A lot of smaller communities still use their town hall, maybe a post office or a library to post their meetings at. And if we don't have a website, that's going to cause some issues. So we're talking about limitations of staff in smaller towns. Making it a requirement to publish this new version within 5 days is also going to be a burden for those exact same reasons. Even in some larger towns and cities, requiring published versions maybe several times a week as the budget's getting redone, which could be, again, burdensome. And then finally, making a requirement that we publish the budget in CSV and PDF formats for easily viewing is going to be difficult. There is no benefit to the towns for doing this. I agree we should be making the budget available to our citizens and enabling them the ability to download this draft budget, which we do. They can make their own changes to it. As they're sitting there listening to it, they can, just as a budget committee member would, they can have a spreadsheet going and they can be making their own changes at that time. But making the budget available to everyone who asks, to us, is our #1 priority. Thank you.
Questions from committee members? Okay, thank you very much, Mr. Devine.
Thank you.
Person.
Next is Elizabeth Dion.
Good morning. Can you hear me?
Yes, we can.
Thank you. My name is Elizabeth Dion. I'm the town administrator for the town of Alton. I oppose House Bill 243 and I have some concerns. Most of them have been mentioned already by previous speakers. Paragraph 1, what is the definition of industry standard? The municipal program that we use does not allow for anything but numbers. Because of that, we also provide a separate backup document with full verbiage, explanations, and breakdowns for each line item. House Bill 243 is concerning because it is requiring one software program for everything. If this passes, we would need to purchase a different software program from a different vendor. This in itself would most likely be an unfunded mandate. I held interviews with software companies 3 years ago, and it is quite an expense to set up a platform and add software programs to it. At that time, it started out at over $100,000 and went up to $200,000. And this would be a financial concern for the town of Alton. Paragraph 2, publishing the draft budget and the revised versions. Mr. Devine just spoke on that. I just have one comment to add to that. People want one version and they want the most current version. And another comment on that too, the 5 days, is that 5 business days, 5 calendars? There were a lot of unknowns here with House Bill 243. And then lastly, paragraph 2, publish in full line item detail, publish where, how many places, for what length of time, how many versions, the most current version or all the previous versions as required in this paragraph. And that completes my speech. Thank you for your time.
Thank you very much. And just full disclosure, I do represent the town of Alton, and thank you for coming. Do we have questions from the committee members? Senator Susie.
I just wanted to clarify, you said that your current software would not accommodate the requirements of the bill, so you would have to purchase something new?
Yes, we would if this bill went into place. We currently use 2 different software programs. And so for the verbiage, which is an explanation and a breakdown of each line item, we use Microsoft Word for that. And then we give both of our documents to the budget committee and the selectmen and so forth. The other one is a specific municipal software program, which is for numbers only, kind of in an Excel format.
Thank you.
You're welcome.
Okay. And I do have a question. Assuming that we scrap the language that's in the bill right now and talk about having sub-account level information available for public inspection that was used to either develop or track the expenses, would that solve most of your problems?
Well, we currently do that already with our monthly revenue and expenditure reports. That I believe the sub-accounts that the proposer was referring to are the 3-digit numbers which are placed after the 4-digit code of accounts from the DRA. So I don't know of a municipality that does not use sub-accounts. So
The question comes in is whether or not they're available to the public.
yes.
Without an RSA, without an RSA 91A request. But if that was the limit to the bill, is that the sub-account level, and the reason I use sub-account is because DRA is supposed to put out that universal chart of accounts. And that's why I use that term, sub-account. That would not be difficult with your own software. Again, if it just said that it had to be available for public inspection.
That would not be difficult for us at all because we already do it. And I believe every municipality already does that, unless there's some other, interpretation of this that I'm not understanding, from the previous proposer.
Yep. All right. Additional questions? Thank you very much. And I hope to get up there to see you soon. This COVID thing is cut down on my visitations of the various towns. So.
We miss you, Jim. We'll hope to see you soon.
Okay.
Thank you.
Do we have anyone else?
Our next speaker is Wayne Gordo.
Mr.
Good morning. Can you hear me?
Go ahead, please.
Thank you, Honorable Chairman and committee members. I appreciate the chance to speak today. I'm Wayne Gortell. I served the town of Hooksett as a member of its school board and served previously on its budget committee. Professionally, I'm a computer software engineer, and my career includes over a decade of developing computer software for the accounting and financial services industries. I'm testifying in support of HB 243 as amended by the House. This is crucial to allow taxpayers, budget committees, and governing bodies to understand how their money is being budgeted and spent, and to assess if it is being spent well. As a budget committee member, I was mandated by New Hampshire state law, RSA 32, to ensure the prudent appropriation of public funds. This required becoming familiar with operations and budgets and carefully looking into budget details, not just rubber stamping the proposed budgets provided to the community. We reviewed spreadsheets of accounting details and whatever back materials were provided to explain these budgets, then interviewed administrators about their requests. Hooksett has nearly 15,000 residents. Consider its $35 million school budget, which has over 1,000 accounting lines and is 28 printed pages. And Mr. Christina had provided some larger examples. How could anybody efficiently analyze this budget? And quite simply, you need tools. Specifically, you must have the budget accounting details as an electronic spreadsheet file, one which can be loaded into a spreadsheet program like Microsoft Excel. And with that kind of program, you can do things on these huge budgets like identifying accounting lines that have had significant changes from the past year, or forecast expected spending by applying an inflation adjustment to past spending, or identify accounting lines where past spending and budget requests don't line up. And during my time on the Hooksett Budget Committee, we did exactly this, which opened up the conversation into the budget and ensured that it was of good quality. Unfortunately, many taxpayers and even budget committee members and governing body members don't have the ability to look at their budgets this way. Many towns and schools do not publish their budgets online, or they give elected officials just paper copies, or they publish them in an electronic format that you can't bring into a spreadsheet program. Specifically, portable document format or PDF is frequently seen, but you can't load that into a spreadsheet program, and that's why the language industry standard electronic spreadsheet format is so critical. Here in 2021, electronic spreadsheet use is so common, it's taught to high school students. And many spreadsheet programs are available for free. We should be making these budget materials available to the public in this format. Senator Susie had asked about materials requests, and while in the budget committee, one year we were denied materials. We had to engage the town attorney. We had to file right to know requests, and unfortunately, we didn't get the materials until after a public hearing. So the committee didn't have its materials to do its job. That's why some of the language about advance notice is critical. I'm not partial to 30 days, but you need something to ensure it's provided in advance for the committee and the public. And finally, regarding this language about line item detail, RSA 3210 provides a really good example, and they reference language individual line items in whatever detailed budget or chart of accounts is regularly used by the municipality. So although there's standard forms towns and such have to submit to the DRA, DOE, etc., I think these sub-accounts, as the chairman mentioned, are not part of those forms. And so that is my expectation of what the line item detail provides. I don't see this as a mandate for new information that's not already there, but it's the information that's often managed by the town, etc., behind the scenes, and just not published as part of these forms. I encourage you to support this bill that mandates critical tools for budget committees, taxpayers, and governing bodies so they can trust that their budgets are done responsibly. Thank you. I would be happy to answer any questions.
Questions from the committee? All right. Thank you very much. Do we have anyone else that's asking to testify?
Yes, next we have Donna Green.
Donna Green?
Thank you. Thank you. Thank you, honorable senators. I am president of the School District Governance Association of New Hampshire, and I am testifying in strong support of this bill concerning transparency in public budgets. The School District Governance Association is made up mostly of past and present elected school board and school budget committee members. Many in our membership have experienced ongoing problems obtaining timely and useful budget information from their school administrative units. It is completely unreasonable that elected officials have to fight to receive budgets in live spreadsheet form, but fight they must in many cases, which is why we initiated this bill. I have submitted written testimony, and I urge the honorable committee members to read my written testimony, but I decided this morning that I would share my personal journey as to how I had problems obtaining public information, of a financial nature. So this bill requires full budget transparency, and transparency is the only mechanism whereby citizens and elected officials can ensure tax money is spent appropriately and to detect and defend against malfeasance. Our budget laws, as I'm sure you know, have no mechanism for punishing violations. So the School District Governance Association has submitted written testimony to you, and now I would like to explain how I arrived here. In 2012 and 2013, I was elected to the Timberlane Budget Committee. And during that time, I became an expert on making right to know requests for basic financial information from my SAU. In 2014, I was elected to the school board. I had 1 year remaining in my budget committee service, and the budget committee appointed my husband, Arthur Green, to the budget committee. So between the two of us, we began really digging into the budget. And we made many right to know requests and had to spend over $100 of our personal money at 25 cents a page to get such things as monthly expenditure reports. In April of 2014, we filed a complaint to the Office of Public Integrity at the Attorney General's office for what we felt were failures of our school district and SAU to comply with RSA 32. So I'd just like to briefly read from that. The petitioners, members of the Timberlane Regional School Board and the Timberlane Budget Committee, are very concerned that the school board and the administrators of the district are persistently failing to comply with New Hampshire budget laws governing the school board, are demonstrating poor financial management, and are engaging in a pattern of obstruction and misinformation in responding to public concerns about these matters. This petition claims that the Timberlane School District has failed to comply with the following financial RSAs during the 2013-14 year. RSA 3210, expenditure of funds in excess of appropriated for specific purposes without proper authorization. RSA 32:8, expenditure of funds for which no appropriation has been made. RSA 198:2-B, acceptance of unexpected revenue without holding a public hearing. RSA 32:5, changing an appropriation amount on a warrant article after public hearing and including the change at town meeting without disclosure. I made that complaint to the Office of Public Integrity. I was given a reply that this did not amount to criminal activity and the AG's office would not pursue it. After which I sent my complaint to our district auditor. I sent it via email and by certified mail. I got a response from the district auditor saying if I contacted them again, they would charge me for their time, and the issues were never subsequently pursued. Later that year, I wanted full line item detail of the school district budget, specifically the salaries for our 400+ employees, a detail level that the school board never saw, that was never ever revealed to the public. I was told that I could come into the SAU office in front of the business administrator, review the 400 pages plus PDF file in front of him, but that I would not be given it in electronic form, not even live, I was asking for it in live spreadsheet form, but I wanted it at least in an electronic PDF file for me to review in my own home, and I was refused this. So at that point, without any representation, I went to the Superior Court and filed a complaint that I was entitled to get this information in electronic form. I lost that case in Superior Court. Then, with the help of Rick Lehman, a very capable lawyer, we went to the Supreme Court. And in April of 2016, the Supreme Court ruled in my favor. And now everyone has a right to demand and receive any information that is in electronic form if they so requested in electronic form. Now, my SAU spent $50,000 of my taxpayers' money to prevent this outcome. Subsequent to this, in 2017, I became concerned about how the school district's default budget was being calculated, and I did not feel it was being calculated correctly and in compliance with the law. So then again, I asked for full line item detail of the default budget, to which I was told it doesn't exist, which I completely do not believe. So once again, I went to Superior Court. And I said, I am an elected official on the school board. I have a right to see the full line item detail of the default budget. And you would think I might have lost on standing, but I didn't, because school board members are required to sign a DRA MSDS, which is a certification that the default budget is true, correct, and complete on penalty of perjury. And I could not in good conscience do that because I was suspicious that it wasn't being calculated properly and I wasn't being given the information to allay my fears. So unfortunately, I lost that case in Superior Court as well, but rather than go through the personal expense of taking this to the Supreme Court, we decided that we were going to personally initiate some legislation to make default budgets more transparent. And this resulted in House Bill 1396 in 2018. And in that year, there were 4 default bills in the House. So they were more or less consolidated into Senate Bill 342. And I'm happy to say that in Senate Bill 342 did pass, to the extent that it said the line item details for changes to the default budget shall be available for inspection by voters. So not every elected official, thankfully, has to resort to the court, and very few of them have the resources or quite frankly, the sophistication to do it. And typically they must be satisfied with much less information than they would desire. I know of one situation 2 years ago where a school budget committee chairman asked the SAU business administrator.
Ms. Green, this is Chairman Gray. If you would wrap it up, I don't usually invoke time limits, but your testimony as to whether you support this bill or don't support it, or the language in the bill that you do support, I think is kind of clear to us now. And so if you would try to conclude your testimony, I would appreciate it.
All right, thank you. As for concerns about unfunded mandates, I'd like to say that every public body uses a spreadsheet program or a database capable of producing spreadsheet output, as was even admitted by the town administrator of Alton. She uses Excel. And even Hart's location, by the way, population of 42, has a beautiful town website where they publish a professional town report every year. So it is not the case that there are towns so small that they have neither a Facebook page nor a website nor a spreadsheet program. And, timely transparency is the very least government owes its taxpayers. And I would really urge you to pass this bill, because there is more difficulty obtaining financial information in the trenches than I think is generally known. Thank you.
Thank you. Do the senators have any questions? Seeing none, thank you. And Kirsten?
Our next speaker is Kimberly Hallquist.
Ms. Hallquist, you need to unmute. Kimberly, can you unmute? All right, there you go.
Sorry for that. Good morning, Chair Gray and members of the committee, and especially to Senator Ward, who's my senator and represents the town of New London so well. Thank you for allowing me to speak to you this morning on House Bill 243, a bill that I oppose. Again, my name is Kim Hallquist, and I serve as town administrator for the town of New London. I'll make my comments brief, given that my colleagues in Hillsborough, Henniker, and Alton spoke so well before me. I will just say that small towns like New London work extremely hard to make information available to citizens as quickly as we can. I think the comments from the speaker prior to me, obviously unfortunate. Many of us work very hard to be as transparent as we can. I feel that HB 243 will unnecessarily add to the work and stress levels of staff in many towns who are already struggling with trying to make as much information as possible, even more information than is required by law, in a timely manner. This all works towards getting the budget to be able to have it ready for a vote at town meeting in March. or in June, as is the case for New London this year, thanks to COVID-19. I thank you for your attention and respectfully ask that you join me in opposing this bill and vote it inexpedient to legislate. And I'm happy to answer any questions that you might have.
Questions from the senators? Seeing none, thank you very much. And Kirsten, we have additional people?
The last person I have signed up to speak is Cordell Johnston.
All right, and while Cordell is speaking, if anyone else wants to speak, you'll need to raise your hand. Cordell.
Thank you, Mr. Chairman. Cordell Johnston, representing the New Hampshire Municipal Association in opposition to the bill. You've already heard from several local officials about the problems with the bill. And as I've listened to the testimony by the people in support of the bill, it's become less clear to me exactly what the bill's intent is. I heard Representative Piemonte, the prime sponsor, agree with Senator Gray that he is not trying to make towns do anything that they're not already doing, but simply require them to make available the budget in whatever detail it is already prepared. And if that's the point of the bill, we have no problem with that at all. It's already the law that whatever is available to the Board of Selectmen or the Budget Committee or the school board must be made available upon request to anyone who asks for it. And as one of the prior speakers said, it sounds like this is more a right to know law issue than a budgeting issue. And if someone is asking for that information and is not getting it, that's a right to know law issue. If you want to clarify that the budget detail that is being used and reviewed by whether it's the Board of Selectmen or the Budget Committee must be available to the public, if you want to clarify that, I think that's fine. But requiring them to do it in a different format than what they already do, I think that is a problem. As you've heard, different towns use different formats. Some may do it in Excel, some may do it in something else, some may do it with a pencil and a legal pad. I doubt that there are any in that last category, but if there are, to require them to put it in some kind of different electronic format, we would have a problem with that. The issue that Ms. Green talked about the school board itself being unable to get budget information from the administrators, that's a very strange situation. I don't know the details of that, but it should not be the case that a school board can't get budget information from the administrators. It seems to me that's a local problem that needs to be dealt with locally. So I guess that's all I have to say, but at the very least, I think this bill needs a whole lot of work. And I'd be happy to work with the committee if you think that there is something that needs to be done. Thank you.
Okay, thank you very much. Questions from the committee? Senator Susie.
Just regarding the very first part of the bill on lines 5 and 6 in particular, it would seem that this bill is trying to make RSA 32 apply to cities, which it doesn't currently. Do you have an interpretation of whether it would just be this section or the whole statute that would now apply to cities?
I guess that's unclear. I don't read it actually as making it apply to cities, because the RSA Chapter 2 or RSA Chapter 32 itself says that it applies to those municipalities and school districts and village districts that adopt their budget at an annual meeting. So I'm not sure. So obviously that would not include cities. I'm not sure that putting something in just one section of RSA 32 that would apply. I guess I would read it as still applying only to towns and school districts that have and village districts that have an annual meeting. But if there's disagreement about that, then that clearly would need to be clarified.
Thank you.
Additional questions? Okay, thank you very much. Is there anyone on the list from DRA that's there but doesn't have the hand raised?
I have a hand raised right now.
Okay.
Good morning, Senator Gray. This is Bruce Canoer, Municipal Supervisor at the Department of Revenue.
Thank you for coming on.
You're quite welcome, Senator. I have been listening to the entire hearing on the bill.
I will, if you don't have testimony, I'll ask you a question. Do you have testimony?
No, sir. I was just making myself available if you had questions.
Okay.
Yes.
My theory on what they're trying to get at is this, what I call sub-account level. The DRA has a charge of putting out the universal chart of accounts, which I believe is in the categories that are listed on the various forms, like the MS 737, 636, 6A, et cetera, et cetera. Is that assumption correct?
That is correct. The forms that you're referring to utilize accounts that are detailed in Revenue Rule Chapter 1700, and they have been in place at that level since the rewrite of the budget law, at least in 93.
Am I also correct in assuming that many towns, and we'll use the police as an example, have sub-accounts which they use to track various functions within that police account?
I do believe that is correct. Just for the record of my past life, I was a town administrator as well at one point. And yes, that would be consistent with the testimony you heard, that in tracking expenditures all year long, as well as building a budget from the ground up, that sub-accounts, as you've described them, are utilized. Yes.
Are any of those sub-accounts subject to providing to DRA at any time during the process?
No, sir. As far back as I can determine, the 4-digit account level has been what DRA has required. Recognizing that the sub-accounts exist during the building of budgets at the local level, and they are utilized during the operation during the year. And I think one of the previous people who testified noted that you can see that from part of the budget law when it talked about individual line items and whatever detailed budget or chart of accounts is regularly used by the municipality. That's language from the chapter that was written in 1993. So it has been a concept well established and in practice for a long time. But we do not see that. We've never required it. And in some sense, it's unnecessary because its use prior to the budget being presented in the forms that DRA has, we don't need to see them. And subsequently, when it gets to the use of it after the appropriations are approved, we're not involved in expenditure questions. So there really apparently has been never a need for that level of detail here.
Okay. For the posting of the warrant, the way I read the statute right now, it does not mandate that you post your MS 737, et cetera, whatever the appropriate one is for your community. But in the annual report of a town meeting, it is required there. Am I correct?
There is a requirement for the budget and the warrant to be in the town report, but it is very typical when the warrant is posted. along with it is the DRA budget form, which is signed by the governing body or the budget committee. And actually will say that this budget was posted with the warrant on a date to meet with the deadline per statute for that posting.
The level of the detail that I've been calling a sub-account level, is there a better accounting term to use to refer to that? Many people use line item or detailed line item. Which would be more appropriate to cite in statute?
Sub-account level is a phrase we hear sometimes. We understand what it is. I think most practitioners at the local level certainly understand it. And in looking back over 30 years, the language at the time that I see would refer to it as detailed level. So I don't think there's any confusion about the use of sub-account level.
Okay, and the definition could be put into 32.3 along with the other definitions that clarified any of that.
I would imagine so. Again, from our purposes, the account codes that are used describing the appropriations that are approved currently have been adequate for the purposes of helping develop the property tax rates. These sub-accounts, as you've heard repeatedly this morning, I mean, they are the building blocks that will sum up to the totals demanded by the revenue rules and on the form. So it's very useful information at budget committee level and voter level, but it's meant to roll up anyway into those larger accounts.
Okay, questions from other senators? Seeing none, did you want to sum up anything before we go on?
No, sir. But if there are any other questions or concerns, please let DRA know. And I will, if it's to me, I will make sure that Assistant Commissioner Lear is alerted immediately.
Certainly, I do plan on writing an amendment to this bill that talks about some of the things we've talked about today. So I will take you up on your offer to help and get with the prime sponsor and anyone else who's on the call that wants to provide information. Send me an email. We may not be able to accommodate everyone, but we'll certainly look at your emails. Anyone else on for hands up?
No hands raised.
Okay. So if we'll give you one more chance for a couple of seconds here before we close this public hearing. Okay, we'll close the public hearing. I would like to have a quick executive session just so we can talk about what's going on with the bills. I don't intend to vote on any bills today, I don't think, but that'll be up to you as a committee. Do I have a motion to go into executive session?
Second.
We have a motion and a second to go into executive session. I will call the roll. Senator Birdsell.
Yes.
Senator Ward. We didn't hear you, Senator Ward.
I'm unmuted. Yes.
Okay. Senator Susie.
Yes.
And Senator Perkins Quokka. And the chair, well, I saw your lips move and say yes, but you are muted.
I did the same thing, yes.
Okay, and the chair votes yes. Just quickly going through we only have one outstanding bill, I believe, and that's 411. I think there's an amendment going to come through on 411, but I have not seen anything come to me yet. So keep that on your list. Going through the bills from today, House Bill 223. It sounded like Senator Susie has an interest in changing some of those words.
Not in changing what's there, but adding just a couple guardrails to it. And I'd like the opportunity, if I may, Mr. Chair, to speak with you and Representative Sweeney, just to add a couple of those things, and obviously Deputy Scanlon as well.
Okay, my notes are going to say you're in charge, so.
Okay, thank you.
Be careful what you wish for.
Hey.
I learned in the Coast Guard, never raise your hand.
All right, the next bill we heard was 285, and we've got several things in there that are going to be provided to us.
Deputy Scanlon is in charge of that one.
Well, in charge of most of it, yes, and so we'll we know what's going on with that one. The next one on the list is 484. And I had that one down as
did no one had any
objections
to it, did they?
Mm-mm.
Look again.
Oh, Representative Horgan sort of did.
Mm-hmm.
though it almost seemed though that some people are interested in looking at that language at the bottom.
I had a note that you were, Mr. Chairman.
Well,
surprise.
I wrote down that Cordell and Diana Power to get together to make some suggestions.
Oh, I remember that. Yeah, you're right.
And I think that it had to do with, you know, things that are clearly budget issues and then things that are auxiliary to the budget, but do have financial impact. So I guess I'll take the lead for the committee, but between Cordell and the prime sponsor, then, you know, I'll expect them to be the ones that work with me or actually provide some language to me to be able to do something.
I have it in the notes that Cordell agreed, so. it's down.
Okay. We'll set that one in stone.
Mhm.
Okay, the next one on the list was 183. And that's soft drink stands. Personally, I have a problem with the age 18. If it were 12, I'd have less of a problem. I might compromise on 16. I think that it needs to state that it'd be on private property with permission of the owner. I look back to selling Girl Scout cookies at various businesses around the area, and that I certainly don't want them to have to go get a permit to sell Girl Scout cookies, but I also don't want them on public land without some kind of a permit, and I don't want them in any hazardous area. And certainly permission of the owner to me also means that the owner is accepting liability for things that went on this property.
I would actually, Mr. Chair, I agree. I think 18 is a little old. I would actually bring it down to 13. I don't know how other people feel about that.
I saw Senator Susie shaking her head.
Well,
and
I guess I'm not aware of what the problem is. This seems to me like one of those solutions in search of a problem. I mean, you know, when you mention liability and I mean, those are issues that people work out now. If somebody wants to sell Girl Scout cookies in front of, you know, a grocery store, they ask permission and they either let them or they don't. You know, I see lemonade stands in my own neighborhood from time to time. Nobody has any objection. I certainly object to the word regulate, because I do think that, you know, where the authorities would step in is if someone was on private property without permission, or if they're in a dangerous place, then they would be asked to move to a less dangerous place. I don't see the need for the legislation.
I would normally, Senator Susie, I would normally be with you, but when I mean, I just on a quick Google search, I found 2, and then I found a third one in Denver, and oh, guess who complained? The child's house was right next to an arts festival. And guess who complained? The person selling lemonade at the arts festival.
Oh.
So they say it never comes here. And I know Cordell said there are states that do stupid things and the towns in those states that do stupid things. Well, what about at some point one of our towns does a stupid thing? Are they going to be back there telling them they're doing a stupid thing? I'm not sure.
The other issue I have with the bill is that, especially if I'm talking people under 18, okay, is that if it is an ongoing basis, that it's every Monday, Wednesday, Friday, every Saturday, every whatever. I have no problem with the occasional one. They want to raise money for the food bank or a soup kitchen or whatever, and it's a, once a weekend for a month. But if it's, like those yard sales that are perpetual, day after day after day, week after week after week, Go ahead, Senator.
Isn't that the same thing, Mr. Chairman? Because like yard sales can be regulated, right? You can create an ordinance that says you can have a yard sale, but only once a week, or whatever time frame they want to put on it. Communities already can do that.
And a lemonade stand could be regulated too, at least with the rules the way I read them here in Rochester.
I don't see why we can't just have the municipalities have
Do
their
it.
own, like they have done already. I'm sort of reluctant to have a state come in and tell you what to do.
And so, if the words were changed, something like nothing in this bill is to encourage communities to regulate soft drink stands for children under, and I'm going to go 14 because it's an even number, years of age that are on private property and whatever. Would that kind of legislation make it through this committee?
I'll have to see it.
Yeah, I just.
I will say that if this piece of legislation doesn't pass and we have a town out there that winds up doing this, I'll be the first one there putting it back in. That's a promise.
Well, ends up doing what? Licensing or saying you're not in a safe place, or forbidding them, is still the right of the town as well, I guess.
Shutting them down.
So again, I'll try to take this one myself and try to craft some words that, take into consideration the requirements there. We don't need a state bird, a state flower, a state whatever.
Or a state spider.
We have constituents who are interested in this bill and would like to have it passed. I also understand that. I think that at least if I take an effort to take into consideration some of the objections that I've heard here and give you back some language, at least we can talk about that language and see if it has any support. So, further comments on soft drink stands? Okay, I could probably use a soft drink now myself, but moving on to 243. I did have long conversations over the weekend with the prime sponsor I told him that my biggest problem with it was that nowhere in his bill or in statute is detailed level budgeting information defined. I did an extensive search on DRA and everything else. And that's where the concept of the uniform chart of accounts that they put out and are used on the various MS reports that are out there, and talking about the sub accounts, which is what I'm used to calling them. And so I guess, you know, I would pretty much take the language that is in the bill right now and do a replace all going in and talking about these sub accounts, and then in the bill somewhere, wherever Legislative Services thinks it's most appropriate, just saying that budget information at the sub account level should be available for public inspection, and if possible, you know, through a spreadsheet or Excel slash CSV. Anybody that doesn't know what CSV is, it's comma separated value. It's a conversion that they use in software to get stuff in. And I think that that kind of threads the needle, is trying to be a compromise and actually you know, get the information that the people want. Some communities are very much provide all that information and it's easy to get, but other communities, whether they're busy or whatever, that it is much more difficult to find. Like I said, I did go through the Farmington, since it's in my district, and look at what they're providing. The annual report does provide the 737 report, which does have quite a bit of detail in it, but for things like, in the two examples I used during the hearing, where the police and the fire, there's just one line item for those. And, you know, being able to identify whether that went up because they added a police officer or a firefighter, or whether it went up because they are looking at adding another vehicle, or whether they're going out and buying new body armor or whatever, I might be able to get a better handle at that sub account level than I could with just that one line item in the MS report.
Mhm.
So comments on that would a change to this bill, which did those kind of things. And again, not saying that they have to break these things down. If I'm at some small community up in the North Country, one line item for police may be all I really need. But if I am in some of the larger communities in the southern part of the state, I may have 20 or 30 subs and subs to those accounts that they really want to track it at and do track the expenses at. So comments on what I've said.
Well, one of the things I picked up was that if that small town doesn't have all the information in all kinds of available electronic versions, they should not have to get a new piece of software in order to accommodate for that. Whatever information they have should be available, but they shouldn't have to go out and do something extra in order to satisfy somebody's request.
And that's why I use the term available for public inspection. Okay. And the reason I would want that in there with all the conversation about RSA 91A is that if the budget hearing is tomorrow. I want the information if I submit an RSA 91A request because they're preparing for the budget. They may not even start that until after the budget meeting, has already concluded because they have 5 days to do it. Okay. And that's one of the reasons why I would like to have some words like that in the RSA so that, if someone walks in and says, gee, I know the budget hearing's tomorrow, I would like to see that detailed level and be able to say, here it is, you can look at it. If you want copies, it's 50 cents a page or whatever our normal, kind of thing is. And saying, using the words public inspection, available for public inspection, doesn't preclude you from doing any of those other things. Like if they want it on a thumb drive and you have it available for charging the fee for the thumb drive as we have in the statute right now, et cetera. So more comments? Suggestions?
I agree with what Senator Ward said and many who testify. They shouldn't have to reconstruct information in a different format.
Right, in RSA
Information
91A.
they have should be made available. And I think there were a couple situations cited where I think the town was wrong in not providing the information. But it shouldn't, particularly for really small communities, impose an added burden of having to recreate and reformat what is information that they already have.
Yeah, and that's consistent with RSA 91A also. If you don't have the information or have it in a, you only have to provide it what you've got and how you have it.
But the couple people that did testify in support were asking for reformatted information.
Understand. And a compromise means, that we don't all get what we want, but we get, something that both sides can say, well, I can support it, a consensus decision kind of to say, but which is what I'm going to try to craft. So if I'm successful, then we'll get a 5-0 vote. If I'm unsuccessful, we may get a 1-4 vote where I vote yes and all of you vote no. So, all of that is possible. All right.
Mr. Chair, if you want, on 285, I can work with Deputy Secretary Scanlon on this as well and run it by the sponsor of the bill, since I'm co-sponsored on this. If you want,
Excellent.
I can take lead on this.
I never turned down a volunteer. Almost never, I should say. Okay, further comments? All right, I think our business is complete. I'll take a motion to come out of executive session.
So moved.
Second.
We have a motion and a second to come out of executive session. I'll call the roll. Senator Bertzel,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. Seeing that our business is complete, I'll get a motion to adjourn.
So moved.
All right, we have a motion and a second. I'll call the roll. Senator Bertzel,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. We are adjourned. Thank you all for your kind attention. And we
Thank
didn't
you.
even get to noontime. So I have provided to Tricia a list of the bills and some proposed dates. And they will start, 4 bills next week, for the week after, for the week after that, and then the last 2, which will get us done, I think, on the what date?
17th. May
17th.
17th.
So that'll leave us a week or 2 to finish up anything else that we have to before the reporting date.
Question.
Yes, ma'am.
I won't be here the first week of May. I'm presuming we're still going to be Zooming.
Yep.
So I could probably Zoom from where I'm going to be housed?
As far as I know, we will still be Zooming. And even if we are in person and doing some hybrid thing, that would not preclude you from doing it. So if
Okay.
I find out anything different, and that would be at the chairs meeting, and you'll be there anyway.
True. Okay.
All right. Thank you all.
Thank you.